Welcome to oral argument. The clerk may call the calendar.
Good afternoon. The Supreme Court of California hearing oral arguments in San Francisco on Wednesday, January 3rd, 2018 at 1:30 p.m. Case number S 110294, the People Plaintiff and Respondent versus James Anthony DeVaggio and Michelle Lynn Michaud for appellant, defendants and appellants. For appellant James Anthony DeVaggio, Mr. David Goodwin. And for appellant Michelle Lynn Michaud, Janice Blair. For respondent, Huey T. Long. Case number S228230. The People Plaintiff and Respondent versus Veronica Lorraine De Hoyos et al. Defendants and appellants. For appellant Veronica De Hoyos, Mr. Howard C. Cohen. And for respondent, Ms. Allison V. Acosta. Case number S111336. In re Vicente Benavides Figueroa on habeas corpus. For petitioner, Paula Fogg. And for respondent, Kenneth S. Suckler.
Thank you. On the matter of the People versus Mr. James Anthony DeVaggio and Ms. Michelle Lynn Michaud, we welcome the Honorable Kathleen O'Leary, Presiding Justice, Court of Appeal, 4th Appellate District, Division 3, and the Honorable Stuart R. Pollack, Associate Justice, Court of Appeal, 1st Appellate District, Division 3. You may proceed when ready, counsel.
Thank you, Your Honor. I'd like to begin with my argument on the reasonable doubt instruction that was given to appellant's trial court. And so in People versus Aranda, which is a case that the Attorney General has cited to this court, the trial court there did not give the reasonable doubt instruction as part of its pre-deliberation packet of instructions. And so what the Aranda court did was it looked at the other instructions given to the jury, including pre-empanelment instructions, to see whether the jury's duty to prove each defendant guilty of each element of the charge of the crime had been given, so that the jury would know what its obligations were with regard to proving each of the counts. And the court then found, Aranda court then found the jury had been adequately instructed on the voluntary manslaughter count, but not as to the active gang member count. And so the court found that that omission amounted to a federal constitutional violation. But then the court then evaluated that omission and ruled it harmless under Chapman. So in this case, the trial court did instruct with the pattern jury instruction as part of the final pre-deliberation package. And what appellant is arguing, or what we're arguing is error, are the expansions upon that reasonable doubt instruction that the trial court gave to each jury panel as the panel came in. And
so can I back up to be clear? Your argument centers around the admonishment that the trial court gave prior to exercising peremptories and cause challenges, then about the burden of proof and the highest burden. And this wasn't so much an instruction being read, it was a speech to the jury, by the prospective jury, by the trial judge. That's what you're concerned about? That's the section you're asking us to
That's the
focus
section that I'm concerned about. And I know that the Attorney General has called that a direction. The court was giving a direction to the jury. But I really do think that the reality is that whatever the court says is instruction. And the Aranda court viewed the instruction, the pre-empanelment instruction, as instruction, and found it was significant in some of its proof. So in appellant's case, the pre-empanelment instructions were incorrect and reduced the prosecution's burden of proof in the ways that are set forth in the briefing. I mean, the court referred to the use of common sense. The court referred to the juror's use of the tipping the scales of the Lady of Justice, which the visual is just like this.
But why would we, given the standard of review for even jury misinstruction, believe that this instruction, as you call it, that came 6 months before the trial began, that was then later superseded by 2 other written instructions that on the pattern instruction of reasonable doubt. Under the standard of review, why would we believe, what evidence is there or inference that this jury used that 6-month-old instruction rather than following the jury instructions as given by the court after the evidence had been presented?
My response to that would be, none of us really knows. The law blocks us from knowing much of what goes on during jury deliberations. And I think that when a prospective juror comes into the courtroom and receives an instruction as to, for example, in this case, reasonable doubt, that the juror is particularly attentive to this aspect of jury selection process. And the reason the juror is particularly attentive is because the juror knows they're going to be asked questions about that during the selection process, not only by the court, but by the counsel. And so I think the juror is engaged and involved in the whole process of what reasonable doubt is, for example. So in this case, what the court did, because jury instructions really often sound as though they are written by a committee, which they are, so the language is sometimes obscure. And so what I think the court did was try to make the language of this reasonable doubt instruction more accessible. But in making it more accessible, the court used terms, for example, when the court talked about imaginary doubt, the court couched that in terms of human interaction and human relationships. And then at one point, analogized it to a decision to making vacation plans 6 months away. And so my argument here is that there's a kind of lowering or leveling of what reasonable doubt actually is. And so, for example, when the court says to a juror, they should use common sense in the context of a reasonable doubt instruction, the law says that the juror should use common sense in evaluating evidence. I mean, we expect them to do that during fact-finding. But I think when the juror is told to do that in the context of deciding when that or where that reasonable doubt standard is, I think that there's a danger there and a lowering or leveling of that burden of proof.
But isn't what the court said to the panels as they were coming in about the use of common sense, didn't it relate to the jury's evaluation of the facts and the evidence and not to its evaluation of whether the reasonable doubt standard has been satisfied?
I think it was open to kind of conflating the two ideas with the example used with the substantial tipping of the scales in conjunction with the Lady of Justice image, the depiction in which the scales...
So that seems like a different aspect of the discussion that you're focusing on as opposed to the common sense and reason. So just to stay on the common sense and reason part of it.
Okay, so I guess I'm not understanding what you're asking me then.
Well, so, I mean, it sounded to me like you just agreed that it would not be improper for a judge to tell a jury that it can rely on common sense and reason in evaluating the facts and evidence presented at trial. Did I understand that correctly?
In evaluating the evidence. But I'm also suggesting that what occurred here was a kind of blending of that with what reasonable doubt, what that standard actually was. And so, I mean, there are cases that say, for example, that I guess it's Sullivan, that talk about not using words like substantial because it's kind of a lowering or leveling of that. So if I could just get back to this one point, I think that because of the way the jury selection process goes on and because jurors are paying attention, I think that in this case, because the court used words like common sense and this depiction of the Lady of Justice, I think that all of those things stay with a juror during the trial and over into the pre-deliberation instructions, which on the other hand, the pre-deliberation instructions are often, they're given in great quantity, 50, 75 instructions sometimes. The judge reads them off. I mean, we're used to seeing in the transcripts the judge saying, you know, almost done, or it's very warm in the courtroom. Everybody stand up, let's take a pause and shake hands, and, you know, so there's a recognition, I think, at the trial level that there is this kind of monotone tedium aspect to the reading of jury instructions. But I think that this business about the Lady of Justice and her scales is something that will stay in the juror's mind's eye. I mean, I would offer that anyway as a reason why I think the instructional issues that I raised on the front end weren't cured by the giving of the standard instructions on the back end. And then Aranda looked also at the instructions.
How much time passed between the two events?
Between the impoundment and the trial?
Yes.
Or
The end of the trial
pre-deliberation,
and the jury instructions.
You know, I don't know. I'm sorry. I don't know. I don't remember that. Do you remember that? I don't remember that. I lost my train of thought. I was going to say that the Aranda court also looked at the instructions that were given in conjunction with each crime to show that the elements of each crime had been proved beyond a reasonable doubt, or the jury had been instructed to do that. And in this case, the trial court gave an incorrect instruction as to the law, which is my second issue that I raised, which is that be guilty language. And so I don't know how we would kind of assess the fallout from the leveling of the reasonable doubt instruction or the standard by the court's earlier instruction, and this instruction that all principals are equally guilty. Because under any of the theories followed by the court, I mean, that would absolutely flat line, I think, the reasonable doubt instruction as to the aider and abetter, particularly the aider and abetter. So I'll just make those points. I want to argue that the inability to assess the prejudice from the combination of the leveling brought on by the reasonable doubt instruction and the error with the all jurors or all principals are equally guilty in combination create an area in which we can't really determine what the prejudice is and what the harm is, and that's of course the structural error argument. If this court were inclined to look at this as a constitutional violation, then I think that we have some showing there that there was prejudice in the way the jury handled count 3. So count 3 is the count in which Mr. DeVeggio sexually assaulted his own daughter. And so the evidence was clear. So by the time the jury reaches the deliberation stage, the jury knows that Mr. DiVeggio has pleaded guilty to that count 3. And the jury also knows that the evidence was very clear that during this time, Mr. DiVeggio is sexually assaulting his daughter. Ms. Michaud is performing sexual acts upon Mr. DiVeggio. And so the jury then asked the court, does there have to be sexual contact between the defendants in order to convict on this count 3? And the court responded, oh, and the jury also asked, or is this a principal aider and abettor situation? And the court then responded by reading again the aider and abettor, all principals are equally guilty language. So there, I mean, I think it's a reasonable inference that the jury attempted to decide that count 3 as relating to April before they got to the murder. And the reason I say it's a reasonable inference is that they were aware that Mr. DiVeggio had pleaded up to it, and they were aware of what the evidence was. The evidence was fairly clear that Ms. Michaud had had no sexual contact with April herself. And so they ask this question that relates to aider and abettor and principals, and the court comes back with the equally guilty language. So in the murder count here, the prosecution presented no evidence as to how the murder occurred or when the murder occurred or where the murder occurred. I mean, we know only that the forensic pathologist has said that the victim died from asphyxiation and there were signs of both manual and ligature strangulation. But as to the rest of it, who was the principal and who was the aider and abettor, the prosecution took the position that both defendants were both aiders and abettors and actual perpetrators, but without defining the acts that they were responsible for. So I think that the problem here, if the jury has received from the court this instruction as to April, and they would just simply apply that over without question. So the prosecution's burden of proving up these separate liabilities then gets reduced again. So the argument basically is that the reasonable doubt instruction was flawed in ways that lowered the burden of proof for the prosecution, and the equally guilty language dealing with the convictions also lowered the burden of proof for the prosecution. I only have one more thing that I'd like to add to that separate principles or equally guilty argument that I made, and that's to make sure that it's clear that the argument applies to all 3 theories of murder, which the prosecution argued felony murder by rape by instrument, kidnapping, and then also premeditated murder. And so the arguments as to equally guilty go to all of those, because the jury would never have to reach the intent, the mens rea aspect for the aider and abettor in the way that the instruction and the evidence was. So, and I guess to the special circumstance as well. So I'm done, unless there are more questions. Thank you.
Thank you, Ms. Blair.
Yes, good afternoon. Thank you. Although I had not put it in my focus letter, if I just add 1 or 2 comments on Ms. Blair's argument, or some questions from the court, rather. First, the question that the instruction or direction she was talking about was 6 months before. I don't think that matters. You know, I've had trials that are 9-month trials, and if in the opening statement, if in the opening instructions, the judge said, well, we're here because we know he's guilty, but we got to do this, it wouldn't matter if it was 9 months before. So the time thing really doesn't matter. The only other thing, and this is my possibly faded memory, but I seem to remember that when jurors are spoken to by the court at the beginning of voir dire, it's opening instructions. I've never heard it directions. I don't know where that term came up with. I may be wrong, but I just don't remember there being directions. So I think it's a distinction without a difference. And at that, I'll leave that argument alone. I'd like to talk about the argument of not allowing Mr. DiVeggio's attorney to rebut argument that Ms. Michaud's attorney had made. And I was thinking this morning that I realized, looking at my notes, that a lot of this is stuff that I plagiarized from other prior defendant cases. And I realized that I think trial courts get locked in a normal routine. And, this is how we do it. And the rules very often require a serious change in the way people think, because the structure is different, the dynamics are different. Having the second defendant or third defendant creates a different structure, and the court, just, oh, this is the way we do it. And I think that's what happened here. Normally, in a case, it's the prosecution will argue, the defense will argue, prosecution can rebut, and there's one defendant, and that's a rational thing because the prosecution can argue whatever he wants. The defendant can go his own way and or rebut, and then the prosecution in closing can't go on a third new thing. He has to just rebut what the defendant says. So in this case, the structure changes. The prosecution doesn't need to rebut it. The only person who really has an interest in rebutting it is Mr. DiVeggio, and he requests time. It's denied. Excuse me. The interesting thing about that, I was looking at it, and there's no reason given that the court, I think they made the argument at one point when they were going over the instructions, and then they come and Mr. DiVeggio's attorney asks for the time, and he says, I'll take it under submission, and then it comes back, and Mr. DiVeggio's attorney says, did you rule on that? He says, oh yeah, I forgot to say it, it's denied. And this court's basically dealing with a situation where there's no reasoning for the denial. Whether there's a need for it or not, it doesn't matter. It's just denied, without any apparent thought to it, except for the fact, the only thing that I can think of is the fact that normally in single defendant cases, this is the structure. It comes up unusually. I don't know if I remember seeing a case, a multi-defendant case, where this particular conflict was created. I've seen cases where conflicts are created because of the multi-defendant case. One defendant testifies and makes an inference of innocence because I testified, which is an implied you're guilty because you didn't, which is a situation unique to two defendant cases, or a case with a pro per defendant. It totally restructures the situation. If it's a single defendant case, one defendant wants to go pro per, okay, that's fine. In a multi-defendant case, it creates a whole different dynamic and structure. But the trial court, is probably not thinking of multi-defendant cases.
Can we step back for a moment? Can you
Sure.
describe briefly what it is that Mr. DiVeggio wanted to present in rebuttal and how it related to the defense he was presenting in the case?
Well, this is the catch-22 of being a poor appellate defense counsel, because he wasn't allowed to present it. And 5 years later, or 7 years later, or 10 years later, a different attorney has to get up here, and a justice is going to, well, I don't know.
But,
Yeah.
so what is the best argument for why
Well, the best-
rebuttal
he-
was necessary?
Okay, I'm going to go back and I'm going to be trial attorney, and you're allowing me this chance, and I thank you for it. Mr. Michaud created the image of my client being the heavy. He did this, he did that. I'm a good mother, and I fell in bad. In fact, she was very active. I don't want to attack Ms. Blair's client, but she brought Amy, I think it was, to the motel or apartment. She brought another one to the apartment. I think it was Christine. She was very active in instigating the sexual acts against the third one, I think, was Rachel.
But hadn't Mr. DiVeggio accepted responsibility for those acts?
Well, she's portraying him as the heavy between the two.
But why would that depiction
Well,
matter for his purposes if he had already accepted responsibility for?
Well, he didn't accept responsibility for all of those. I mean, but it's painting him as the heavy. And it's not that he's the heavy. It's she was not the goody two shoes. Santalina. She was not the goody two shoes of the pair. She was, but she is able to paint him that way. And it's a thing that sticks with him throughout the rest of the case. He's still in the penalty phase where it does matter more, where it's more individual. But the fact is that's the argument that I would make 10 years later. I don't know what the argument that the actual trial attorney would have made, because, as I say, he wasn't allowed to rebut. He felt he had the need to. I mean, clearly he had the...
extent that the argument being made concerned their relative roles and the idea that Mr. DiVeggio was controlling and was the heavy, as you put it. Was that a strategy or a theory that had been advanced earlier in the proceedings as well?
I don't remember that theory being presented earlier. I'm trying to think of the guilt phase evidence. I don't think there was that much. I don't remember, to be honest. I think that's the first time that there was this, that she started portraying him as the heavy.
Didn't she call an expert witness who testified about the degree of control that he exerted in the relationship?
Yes, that's right. And there was, but that's, he didn't have a chance to rebut that.
And did Mr. DiVeggio call a rebuttal witness?
No. Oh, his defense after, I take that back. His defense after, trying to remember now, he did argue that she, I think that she was involved in it. I don't remember exactly how, 1 second. Oh, yeah, there was a woman that he had dated who had said that Michaud was like very infatuated with him and, was, let me see, so there was a partial, rebuttal of a rebuttal witness. But again, the fact is he didn't get a chance to argue it after he was accused in argument. And argument is an important part of the case. How many prosecutorial misconduct cases are based on, improper argument? And in a multi-defendant case, this becomes the second prosecutor. the second prosecutor, who's not necessarily bound by any particular restraints that normal prosecutors are bound by. It's not bound, it's a totally different thing. So, I think it becomes a different factor in that. If there's no other questions,
Thank you, Mr. Goodwin.
thank you.
Good afternoon, Madam Chief Justice, and may it please the court. I first want to address the issue raised by Appellant Michaud regarding the reasonable doubt directions and instructions. As this court accurately noted, those challenged directions were presented at the voir dire process. That process began in August of 2001. The trial did not begin until 6 months later, and the deliberation process did not begin until May of 2002. So from the time of the initial direction regarding reasonable doubt and the final corrected and written form of the instruction, that was properly presented to the jury. There was an 8-month lapse. And why is that significant? That's significant because we have to determine if there's a reasonable likelihood that the jurors were misinformed about the law regarding reasonable doubt and how it applies to this case. And the chances, there was no evidence to suggest that during that 8-month window, the jury was in any way conflicted or confused about what the definition of reasonable doubt was.
You don't contend that the instructions given at voir dire were correct?
What our contention is that they presented an incomplete picture of what the definition of reasonable doubt was. But there's case law that does say, and we've cited in our brief, that certainly the court can introduce general concepts to the jurors pre-trial, so long as those instructions are completed prior to deliberations, there would be no error. So our position is that they were incomplete, but were supplemented and completed with the standard reasonable doubt instruction prior to the deliberation.
I don't think the scales of justice metaphor is an accurate one, do you?
That particular direction, in and of itself, if it were presented in a vacuum, yes, it would be misleading with regard to the definition of reasonable doubt, but it wasn't presented in a vacuum. And if you look at the totality of the instructions that were provided regarding reasonable doubt, there's no reasonable likelihood that a jury would have been confused about the definition of reasonable doubt in this
You're talking
case.
about the totality of all instructions provided over the course of the entire proceedings, or the totality of instructions provided at the time?
The entire proceedings. And what is most crucial is the actual written instructions and the instructions that the court read prior to the deliberation process, because that is the last word on the law and the definitive word on the law that the jurors are provided when they are about to make the ultimate decision, in the case, the findings of facts. And because there was no error with regard to that, and looking at the totality of everything that happened, we would submit there was no legal error. Now, if there are no further questions regarding the reasonable doubt instruction, I want to switch to the equally guilty language that both defendants have raised as a focus issue. Now, the specific instruction at issue states that each principal, regardless of the extent or manner of participation, is equally guilty. Now, the concern that appellants raise here is that they will be liable for the mental state of the other, that they would be vicariously liable without an independent assessment of their own guilt and their own mental state. Now, that concern is unfounded, and the reason that is because CalJIC 3.00, which is the instruction at issue, is not read in a vacuum. It is supplemented by 3.01, which states the 3 specific additional findings that must be made in order to establish aider and abettor liability, specifically requiring the aider and abettor to know of the direct perpetrator's intent, and secondly, that the purpose or intent of the aider and abettor was in fact to aid and assist or encourage that direct perpetrator. And with those specific elements actually provided in addition to the language of equally guilty, no reasonable juror would have determined guilt purely on this vague direction that principals are equally guilty. And what's more, there's further instructions that say that the jurors are to determine guilt separately. And as this court has noted, Mr. DiBaggio pled guilty to 3 of the counts. And that is significant for this issue because when the court was instructing the jury, it added specific directions that said that you are not to use that information to implicate Michaud. And it addition said, you must find each element of the murder count in special circumstances beyond a reasonable doubt for each defendant. So with those extremely clear instructions regarding what elements are to be established and that liability must be determined separately, there's no reasonable likelihood that the jurors would have been confused by the equally guilty language.
Does that argument depend at all at on the particular circumstances of the case? Like, would you say, you know, if there were reason to believe that the two participants in a crime may not have shared the same mental state with respect to the crime in a first-degree murder case, that there might in some circumstances be some confusion engendered by that set of instructions that is not present here because of the particular circumstances of this case?
Yes, I think that in certain circumstances, if you do have more of a contested issue of what the mental state of the aider and abettor was, potentially the equally guilty language could be somewhat at odds with what the different liabilities would be. And as we note, the CalJIC and CalCrim have certainly been modified now to account for that circumstance and for the possibility of different levels of liability. But in this case, that's not true whatsoever. If we look at the intent of both defendants, specifically with regard to the murder, they were both involved in the planning process. They both talked about hunting prior to the murder. They both tried to actively recruit other people to become involved in this partnership in order to abduct young women and sexually assault them and do terrible things to them and ultimately silence them in various ways. There's no convincing evidence whatsoever in this record that suggests that the defendants had any lesser mental state than first-degree premeditated murder. And in fact, Mr. DiVaggio's defense in closing was that his intent all along was to murder and not to kidnap or commit rape by instrument. And so this is a case where there was simply no reasonable interpretation of the evidence that would suggest there were different levels of culpability or mental state.
Michaud did raise a theory that she had gone along with Mr. DiVaggio in these crimes because she was being controlled by him. How does that relate to?
Yes, I would say two things to that particular defense. Number one, as we've noted, duress is not a defense to a capital offense, nor is it can it be used as a defense to diminish premeditation or malice. And secondly, Ms. Michaud's defense was a generalized statement that, yes, I was a victim of PTSD and I was under the domination of DiVaggio. However, there's no evidence of that with regard to the actual offenses and crimes talked about in this case. From everything that we know, she was an active participant in every step along the way. She drove the van. She modified the curling irons, as evident by the fingerprints on there and the duct tape. She was seen at various points, with the defendant at all pertinent times that they were seen by witnesses. And so her defense was completely untenable here. And so what this case shows is that the equally guilty language was not in any way problematic for the jurors. And that is evident by the fact that they didn't ask any questions with regard to the aider and abettor liability or with regard to the capital case and murder. Lastly, I want to address defendant DiVaggio's issue regarding whether or not the trial court abuses its discretion in denying his second argument. This is an abuse of discretion standard, and the court here was justified in denying that second argument because DiVaggio already had a closing argument. He had two counsel who spoke and presented his defense, which was essentially in order a theory that the special circumstances were not proven. He essentially admitted to the first-degree murder. He was just simply trying to challenge the special circumstances. Michaud's defense case was merely regard to her case, and there was no specific theory that Michaud advanced that disadvantaged Debaggio or his defense in any way or shape or manner. And we would submit that the court was well-reasoned in denying that second argument. Unless the court has any further questions, we are prepared to submit.
Thank you, Mr. Long.
Thank you.
Just very briefly, as to the argument that the equally guilty language in 3.00 was offset by the 3.01 and 17.00 instructions. I mean, I don't know, I don't think the jury would even have to get to 3.01. I mean, nothing is clearer than the principles are equally guilty. And so once that's made clear, and it's clear in that instruction that the principle is an aider and abetter, why would they even get beyond the 3.01? I mean, so that's as to that. And as to evidence as to the Attorney General used the plural in referring to the defendant's plan to kidnap and sexually assault and murder, but there was only one murder that was done here in the Alida kidnap and sexual assault example that was admitted by the court for identity evidence. There was a discussion amongst the two defendants as to what they were going to do with Alida now that they were done with her, and Debaggio left it to Ms. Michaud, and Ms. Michaud dropped her off. She was driving the van and stopped on the roadside and dropped her off. So there was no killing there, and certainly not with the other incidents. There was this woman, Amy, who was handcuffed and hit on the back of the head with the gun, and then says she heard the gun click, but obviously the gun was empty. So there, again, no intent to kill, and they release her. And the same kind of analogy goes on with all the other evidence. I mean, it's clear that they take these women and girls and they subdue them and physically and threaten them, but in the end release them. And so in this case, there's no prior knowledge on the part of Ms. Michaud in the aider and abetter capacity as to what was going to happen with Vanessa Sampson.
What about the evidence that she had spoken, asked, I think it was April, whether she wanted to go hunting with her?
Yes.
That pretty much...
I know that the Attorney General and the trial prosecutor's spin on that was that they were hunting to commit murder ultimately. But I don't know that ever came out in the conversations and the actual conversations between the parties at the trial. I mean, it was in the defendants at the trial. The hunting was for sexual assault purposes, not for murder purposes. The prosecutor chose to spin it as murder as part of her proof of what happened. So, thank you. Thanks very much.
Thank you, Ms. Blair.
A couple points briefly. I think counsel said, and my notes were not very good, something that at the defense stage in the evidence, Ms. Michaud didn't present evidence blaming Debaggio, but that was in the argument. If that's true, then he's arguing facts that were not in evidence, which makes it more important to have the chance to rebut. I may have misunderstood. If I did, I'm sorry. The other thing I'd just like to address is the hunting and all this and the intent. There was a lot of evidence that on a very superficial level would indicate intent to kill. If you take hunting, if you take the serial murder baseball cards, But the bottom line is that, except for Vanessa, they didn't. They didn't go serial killing. They didn't go, whatever it was. They did engage in very nasty mind games with Alita, the woman in Reno, of playing the Folsom Prison Blues that shot a man in Reno, you have to watch him die, and the clicking of the gun and all that. But the bottom line is that with all the talk about killing a person in Reno, they didn't. The bottom line with with the gun, he didn't reload if it was empty. He didn't fix the jam. The hunting, yeah, they talked about it, but the fact that they never did is kind of rebuts at least the serial killer aspect that was a big part of the trial. There's no questions, I'll sit down.
Thank you, Mr. Goodwin.
Thank you very much, Your Honor.
Thank you, counsel. And as you all know, the matter will be submitted on the date that the last answer brief is or could be timely filed under order by this court. Thank you. Calling the People versus Veronica Lorraine de Hoyos, and we welcome the Honorable Henry E. Needham, Jr., Associate Justice, Court of Appeal, First Appellate District, Division 5, sitting pro tem. You may proceed when ready, counsel.
Good afternoon, Your Honor. Howard Cohen, on behalf of the appellant. May it please the court. In this case, the electorate's intent, whether Proposition 47 applies retroactively to appellants whose appeals are not final, is really bounded by four considerations, and those considerations are the propositions, a text and an argument, the Estrada-Kirk jurisprudence, statutory construction principles, and most recently, although not involving Estrada-Kirk itself, this court's opinion in Valencia, which serves as a primer which elucidates all of the prior former principles that I just stated. The intent of the statute or the proposition, the respondent and the appellant both refer to the electorate's intent, which is obvious. But from there, there's a decisive schism. The respondent basically focuses myopically on two words. Appellant looks at the entire proposition, the whole proposition, the 10 substantive changes, or in this court's summation in Valencia itself, the primary focus was reducing the punishment for a specifically designated category of low-level felonies from felony to misdemeanor sentences. Moreover, that wasn't the court's words, my word, moreover, require misdemeanors instead of felonies for non-serious, non-violent crimes like petty theft, etc. That reduction from felonies to misdemeanors is not only reducing the felony punishments from wobblers down to less than 1 year, but their status from felonies to misdemeanors, which has various collateral consequences. When person might apply for a job or seeking bonding, they're no longer a felon. That was the electorate's primary focus. Or when the electorate picked up its pamphlet and opened it up, that was by far more description to the electorate of the sweeping substantive changes in comprehensive reform. To boot, the cost savings that was to inure to the public for schools and other benefits to the public. By far, that was the public's intent in enacting the proposition. Now, in addition to that, what the elector was reading, we have to turn to what the statutory principles of looking at at such an enactment.
In light of
sorry?
resentencing provision 1170.18, what do you think the electorate intended?
1170.18.
Yeah, the resentencing provision under Prop 47.
1170.18 is the petitioning process, and the question is whether an appellant whose appeal is not yet final falls under that or is bound to Estrada defendants as they have been for more than a half century. Under Estrada, the same day the Supreme Court, this court, wrote in Kirk that Kirk defendants were to be treated precisely the same.
Okay, looking at your argument basically is that Estrada applies in this particular case, but in light of the fact that we have 1170.18, isn't that tantamount to a savings clause?
No.
That would exclude Estrada from being applied?
No, it is not, and there's several reasons why it's not. First, before you look at a savings clause, or think of it as a savings clause, you have to think in terms of what the electorate had in its mind. In the cases that this court has determined that it's a savings clause, for example, Pedro T., the court looked at the legislative history that said that auto thefts were a crisis.
Well, that's an interesting case, by the way. Is this a stronger case for retroactivity than Pedro T.?
Than Pedro T.?
Yeah,
no.
You were, if I understand it, you were counsel on that case. And,
I was.
And you argued that
sitting
in front of Justice Werdiger.
I'm sorry?
And you argued that in front of Justice Werdiger.
That's true, I did.
Yeah. Is this a stronger case?
No, this is a much stronger case because...
Why is that?
Because in Ray Pedro T., there was one offense. That was Vehicle Code Section 10851. And it had gone up momentarily, and there was a sunset provision. And this court said to make a valid test of whether there would be an enhanced deterrent, it would not make sense if the potential culprits knew that it would come back. And therefore, and the legislature in its enacting legislation talked about the crisis that existed. Now here, if you look at the electorate's ballot provisions, where they're reducing 10 wobblers and a couple of straight felonies down to misdemeanors. And moreover, how having in 1170.18A, not 18A, in F, giving relief to people whose convictions are long final, who could have committed these offenses 5 years ago, 10 years ago, 20 years ago, who have been laboring under felony burdens for decades, that shows a great amelioration, not a legislature who is concerned about a crisis in auto thefts. This is a very beneficial, great beneficent legislation. Or as
in
this
that
court...
case, in Pedro T., really, you know, as it was expressed in Justice Werdiger's concurrent opinion, in that case, Estrada did not apply in where there was an enhanced punishment as opposed to a lesser punishment because of the amendment. In her concurring opinion, she says Estrada is still alive and well, basically.
No question.
But you have to go through this process of looking at what the legislature or the electorate intended. And so that seems to be the bottom line. And it seems if you look at this case and looking at Prop 47 and the resentencing provision, it seems that the electorate intended that those serving a sentence, whether final or non-final, should have the benefit of the provision.
If I may, Your Honor, there are two responses. First, in 1170.18, you would be looking at two words out of the whole proposition. And in this court, in Valencia, quoting from another past precedent, said, isolated statutory language can be informed by, and indeed must be consistent with provisions of the relevant statute as a whole, and must be construed in the context as a whole and the overall scheme. The overall scheme of Proposition 47, of which 1170.18a is one small part. When I was reading the briefs, I came across a phrase we had used, the tail wagging the dog. Really here, it's the tail wagging the elephant. The elephant is the whole proposition, not currently serving. And indeed, if you look at 1170.18, currently serving is one portion, and the electorate, if they were to look at that, would have also seen completed sentence. The two go hand in hand. And by those two going hand in hand, the electorate reading that would have put one against
You
the
don't
other.
think this includes, Prop 47 includes a completed sentence?
I'm sorry?
You don't think that Prop 47 includes a completed sentence?
Yes, it does. And then under F and G.
Yeah.
Now, so currently serving has to be, if you read that section by itself, just by itself, currently serving would be contrasted or placed in contradistinction from completed sentence, because they have two different regimes when you petition and thereafter what occurs. Because two different things occur when you petition under A, when you petition under F, and they are placed in, or they occur depending whether you're currently serving or whether you've completed a sentence. So that if you're a month away from completing your sentence, you might as well maybe wait a month, unless you're really, really in a hurry, to go into the completed sentence regime. So those are different ways of saying why currently serving should not dictate to the that the whole scheme takes precedence.
As a matter of just ordinary usage, as we normally use language, setting aside the other provisions of Prop 47, would you agree that currently serving a sentence is generally used to refer to people who are currently incarcerated on an offense, regardless of whether or not?
If you looked at it in an isolated way, yes. If you looked at it in an isolated way. But in this scheme where we have Estrada Kirk, also in the Estrada jurisprudence, in one of this court's precedents, it says that in the specific context of Estrada, when there's a mitigated sentence punishment, there is an articulated reasonable presumption that it applies in a non-final judgment, unless the legislative body, here the electorate, makes it sufficiently clear, there's sufficient clarity for the reviewing court